But when, as a student of law, we read the interpretation of statutes and how the statutes have to be interpreted, there seems to be three things which have to be kept in mind. That the legislation can be examined by strict construction, liberal construction, and harmonious construction. Now, when I read Madhyastham Adhikaran Adhiniyam, I find that this is a perfect law which provides for everything, cater to the needs of all exigencies, includes each and every component of the litigation arising and flowing from a works contract. Yeah. Yes. And therefore, my argument would be having two aspects of the matter. First of all, I will be saying that the Act is a perfect, complete code in itself. It can take care of all kind of aspects of the matter. And second would be the submission in relation to the blacklisting. So to advance this for submission, I would request my lords to refer to the preamble of this Act, Madhyastham Adhikaran Adhiniyam 1983. This is a 4 lines preamble, which says, may I read more? Yes. An act to provide for the establishment of a tribunal to arbitrate in disputes to which the state government or a public undertaking, wholly or substantially owned or controlled by the state government, is a party, and for matters incidental thereto or connected therewith. So this gives a larger scope and sweep to this legislation, that this is not only relatable or related to the contractual matters where loss or compensation alone has to be seen or ascertained. And again, we'll not read in a flow. An act to provide for the establishment of a tribunal to arbitrate in disputes to which the state government or a public undertaking, wholly or substantially owned or controlled by the state government, is a party, and for matters incidental thereto or connected thereto. There are situations and circumstances where sometimes the preamble of the Act do not reflect in the relevant provisions of the enactment. But here's a case where in Section 3, when the tribunals are constituted for the purpose of adjudication of these things, it has been clarified. Now let's kindly see Section 3, Constitution of Tribunal. The state government shall, by notification, constitute an arbitration tribunal for resolving all such disputes or differences pertaining to works contract arising out of or connected with execution, discharge, or satisfaction of any such works contract. In my humble submission, this is the widest possible definition and the widest possible powers given or attributable to such kind of a tribunal created under this statute. So when I try to understand the scheme of the Act, I find that this is a perfect code in itself, providing for all kind of exigencies. But when I read the definition of dispute in Section 2, Clause D, it starts restricting the scope. The meaning of disputes is given in Section 2, subsection 1, Clause D. Dispute means claims of ascertained or ascertainable money valued at rupees so and so or more relating to any difference arising out of the execution or non-execution of a works contract or part thereof. So it provides for two things. It has to be a claim more than 50,000. Number two, it should be relatable to a works contract. Now further, when the works contract is defined in Section 2.1, Clause I, it again enlarges the scope. I says works contract means an agreement in writing or a letter of intent or work order issued for the execution of any work relating to construction, repair, or maintenance of any building or superstructure, dam, wire, canal, reservoir, tank, lake, road, well, bridge, culvert, factory, workshop, powerhouse, transformer, or such other works of the state government or public undertaking or of the corporations of the state as the state government may by notification specify in this behalf at any of these stages entered into by the state government of an official. I'll skip one of this and come to the last 4 lines, and includes an agreement for supply of goods or material and all other matters relating to the execution of any of the said works, and also includes the services so hired for carrying out the aforesaid works, and shall also include all concession agreements so entered into by the state government or public undertakings or corporation wherein a state supports is involved or not. Then subsection 2 says words and expressions used shall assign by the Arbitration Act. So this scope a lot still gets enlarged, that if it's a works contract, it will take into sweep all kind of works. So the first thing is preamble, second is section 3, then the two definitions of works contract. We'll also kindly come to section 7, capital A, which provide for the preparing of the reference petition. This provide for the procedure primarily, but it takes into consideration the nature of the claim, which has to be presented before the tribunal. Section 7A provides for reference petition. Subsection 1 says every reference petition shall include whole of the claim which the party is entitled to make in respect of the works contract till the filing of the reference petition, but no claims arising out of any other works contract shall be joined in such a reference petition. 2. Where a party omits to refer or intentionally relinquishes any claim or any portion of his claim, he shall not afterwards be entitled to refer in respect of such claim or portion of claim so omitted or relinquished. 3. Notwithstanding anything contained in subsection 1 or subsection 2, disputes relating to works contract which may arise after filing of the reference petition may be entertained as and when they arise, subject to such conditions as may be prescribed. Pausing here for a moment, this is the first limb of my argument that this is a complete code in itself. If we read aloud subsection 1, it says that the claim still filing of the petition can be filed. So in case no blacklisting order has been passed and only termination order has been passed, this will fall into the category of 7A1. But suppose subsequently, on account of some proceedings, a blacklisting order is passed, it will be covered in subsection 3. Subsection 1 says till the filing of the reference. Subsection 3 says after filing of the reference. So nobody can make a grievance that at that time it was not a composite order. Separate orders were passed. Firstly, I approached the tribunal, lodged my claim, and thereafter it was filed. Therefore, I have come to the High Court. This gets the answer in section 7A. That all possible things have been stated about the reference and the rights of the parties. Therefore, 7A completely answers this. Now, we're going to kindly see two provisions of section 16 and section 19, where award and appeals are provided. Section 16 provides for the award. I will not read the entire text. I'll simply read the explanation appended at the bottom of, section 16 provides for the award, which says provided after subsection 1, provided that the tribunal may make an interim award. May I read again? Section 19, subsection 1. The tribunal shall, after recording evidence, if necessary, and after perusing the material on record, and on affording opportunity to parties to submit their arguments, make an award. Provided that the tribunal may make an interim award. Provided further that the tribunal shall give reasons in brief for an award, including an interim award. Now, whether an appeal would lie of the interim award or not can be seen in section 19. An explanation has been appended at the bottom, where the power of revision to the High Court have been provided in section 19. Section 19 says High Court's power of revision. And the explanation says, for the purpose of this section, an award shall include an interim award. Now, if I utilize these two provisions of section 16 and 19 to demonstrate that I have lodged my claim along with the challenge to the blacklisting order, and I'm making a prayer to the tribunal that kindly pass an interim award so far as it relates to my blacklisting part, the tribunal will feel satisfied, hear the parties, and pass the interim award. And no rights are affected. Nobody can raise a grievance that will take a lot of years. So from this perspective, when the tribunal possesses the power to pass an interim award, I can always safeguard my interest and the interim proceedings and the interim rights which are affecting, resulting into loss and future losses. And the tribunal would definitely pass the interim award. In case I am dissatisfied at that stage where my original reference petition is yet not decided, I have asked for passing of an interim award in relation to my blacklisting, and suppose the tribunal says that we will not stay the blacklisting order, I have a remedy under section 19 to come to this honorable court by preparing a revision petition that this interim award, which has curtailed my right for the blacklisting, is incorrect. Kindly correct this in your revisionary powers. So an interim award can be challenged and is challengeable under section 19. So from this perspective,
how you reconcile 16 proviso with section 17A? There are two eventualities. One is that can interim award be passed at the threshold without taking the evidence, etc.? Because section 17A seems to be restricting the power of passing interim orders.
Definitely, I'm grateful. I was coming to this point. I'll just read out section 17 there to demonstrate this. Inherent powers. Nothing in this act shall be deemed to limit or otherwise affect the inherent powers of the tribunal to make such order as may be necessary for the ends of justice or to prevent abuse of the process of the tribunal, provided that no interim order by way of injunction, stay, or attachment before award shall be granted, provided further that the tribunal shall have no power to review the award, including the interim award. I am not asking the tribunal to pass an injunction in my favor. I am not asking the tribunal to stay the proceedings. I am not asking for an attachment. I am simply saying that since this is affecting me, therefore, at this interim stage, you may kindly pass the interim award that this is contrary to law and it is hereby certified.
17A talks about order and 16 talks about award.
Yes,
There's a difference.
that's the major difference. Now, in case I can bring my case into the category of award,
Interim award.
the tribunal will say that this is an award, and I will be in a position to demonstrate that I am not asking for something which requires interregnum arrangements. I'm asking for quashment of the award. I'm asking for the quashment of the blacklisting order. If this analogy is presented of the tribunal might be persuaded from this
We are
aspect.
trying to understand, as brother has rightly pointed out, 17A talks of order, 16 talks of award. Can an interim award be passed without taking evidence on record?
The act nowhere bars for that.
Anything. Therefore, we are
It's
asking
simply-
you to explain
It's simply
whether within the sweep of section 16, an interim award can be passed at a threshold without taking evidence of either of the parties.
I'll answer my lord.
One will make it.
I'll answer this still under section 16 and 19. Section 16(1) says the tribunal shall, after recording evidence, if necessary, and after perusing the material on record, and on affording opportunity to parties to submit their arguments, make an award, provided that the tribunal may make an interim award. Now is the requirement in second proviso. Provided further that the tribunal shall give reasons and brief for an award, including an interim award. So this is the only requirement. So far as adducing evidence is concerned, Order 18 of the CPC gives me the authority to subscribe to the affidavits, the counter affidavits, and the court will.
The court says if recording evidence if necessary.
Yes.
The court finds that
Is it
no
not
evidence is
necessary?
required, prima facie that can be done.
I'm ready.
Interim order can be
I'm
passed.
ready. So the only requirement of passing the interim award is that the tribunal has to give reasons.
Reasons.
And in case tribunal has given the reasons based upon the facts of the case, it will be an interim award and not interim order, satisfying the requirement of section 16(1), second proviso. And now, my lord, I'll come to section 19, which in my humble submission would be a test, as my lord has asked this question, as to whether such questions would arise or not arise before the High Court. Now, what and on what parameters High Court will read and analyze the revision, that can be seen in section 19, subsection 2, because grounds have been specified that on these grounds alone, the High Court can entertain a revision or allow a revision or dismiss a revision. Section 19, subsection 2 says, may I read now? 19 says High Court's power of revision. Subsection 2, if it appears to the High Court that the tribunal A has exercised its jurisdiction not vested in it by law, or B has failed to exercise the jurisdiction so vested, or C has acted in exercise of its jurisdiction illegally or with material irregularity, or D has misconducted itself or the proceedings, or E has made an award which is invalid or has been improperly procured by any party to the proceedings, the High Court may make such order in the case as it thinks fit. So there's a complete supervisory power ingrained in all these clauses.
This is included interim award also.
Yes, because it has already been stated that appeal would like, the explanation says this of section 19, appended at the bottom of the section, explanation, for the purposes of this section, an award shall include an interim award. So, just my lord, visualize the situation where a petition, a reference is filed, challenging all these things, including the blacklisting. A prayer is made for deciding blacklisting issue as a premier issue. Tribunal is satisfied, passes an interim award. Somebody is dissatisfied, he can challenge that under section 19 before the High Court. And High Court immediately can exercise his power, not only of supervision, but if we see the words, they are akin to Article 226. Lastly, E says, section 19, subsection 2, clause E says, if it appears to the High Court that the tribunal E has made an award which is invalid or has been improperly procured by any party to the proceedings, the High Court may make such order in the case as it thinks fit, including A to D. All such powers are equivalent to the powers prescribed and available to the High Court under Article 226. Now, the last limit can be gathered from subsection 3 of section 19, which clarifies that High Court, while entertaining a revision against the award of the tribunal, shall exercise the jurisdiction available to it under section 115 of the CPC. So all the doubts are clear. If somebody says that you have this power to do it, it is covered under subsection 2. If you want to restrict the power by saying that we will exercise the power of revision in a narrow manner, 115 comes to the rescue of the parties and the honorable court under section 3, subsection 3. So 19.2 and 19.3 gives complete guidance and protects the interests of all concerned so far as their claims are concerned. And that is why, my lord, the Supreme Court in several cases have said that since the Madhya Pradesh judgment is providing for an independent remedy, therefore, in spite of the fact that Arbitration and Conciliation Act has been brought into existence, the jurisdiction will not go. In 2 of the cases, right from LG.
Pooch for related MPRDC.
Yes, there also it has to be Pooch. So, in my humble summation, the first limb is that this is a complete code in itself. It answers all kind of queries, all possibilities, eventualities can be addressed, questioned, adjudicated, and decided. Now, I'll come to the second aspect of the matter, whether order of termination or order of blacklisting falls into the domain of the tribunal or not. My lord has asked this question.
Yes.
My lord has asked a question as to whether he will challenge the termination order in tribunal and blacklisting order in High Court, or what is your take on this? My humble submission is, rather emphatic submission is, that I will challenge both before the High Court. The legality of the termination order, the legality of the blacklisting order. For that purpose, doors of the tribunal are closed for me. It's only the claims.
If it is a composite order,
Even then, if I want to challenge on the ground of legality that the termination order is bad in law, tribunal has no jurisdiction. It has a jurisdiction to a limited extent of my claims, my losses, my compensation. It has nothing to do with the legality of the termination order, because tribunal doesn't have the power to quash the order of termination. But has no power.
But unless and until it is determined that the order of termination is illegal, how can compensation it being a
That is
constitutional
not-
relief be granted?
So,
See, first,
so
the first determination will be that the termination is illegal. Then only consequential relief will follow.
So the person will not go to the tribunal. He will first of all seek determination at the hands of the Honorable High Court, because the legality cannot be challenged there. Despite the efforts, despite the wisdom, the tribunal will refrain its hand from this issue. We will not touch this aspect of the matter because it is not provided in the Act. We can simply say that
अभी आप
this,
कह रहे थे comprehensive code है.
that's right. That's why I said
Sweep है.
that's. I'll clarify. That's why I was saying it has. My argument has 2 limbs. And therefore, I will conclude by saying that this act provides specifically for specific problems. It's not a cure for all problems. It's a complete code in itself for the subjects engrafted in the legislation. And that's why, my lord, I'm saying that whatever has been restricted or constricted can be seen in the definition of 2D. That is the only subject matter of the tribunal, not beyond that.
Only puts 2 limitations. See, this is our understanding,
No.
or rather, this is my understanding. One is quantum, that claim should be above 50,000 rupees, and 2, that it should originate from a works contract. Works contract is defined in section 2 only.
2I.
There are only 2 limitations, but when we read section 3, then we cannot say that it is restricting. As you said, that definition of works contract is wide enough to include everything within its suite.
Well, I will put it in a different manner. It's not a restriction. It's a prescription. Section 2D dispute definition provide for something.
Prescription restricts you.
I'll just clarify. What is
See,
first
if,
of all-
if I have to go to a doctor and he prescribes me certain things, that means that he's restricting other things.
in the definition of the provisions of law? I'll try to canvass my point of view. It says that you will decide the disputes. I'll come out to preamble again. An act to provide for the establishment of a tribunal to arbitrate in disputes. May I read again now? An act to provide for the establishment of a tribunal to arbitrate in disputes. I'll pause here and again come back to the definition of dispute. 2D says dispute means claim of ascertained or ascertainable money valued at rupees 50,000 or more relating to any difference arising out of the execution or non-execution of a works contract apart thereof. So what is the scope of the powers or the sweep of the powers of the tribunal can be seen in the definition of the dispute. It's a restricted definition which provides that it has to be a claim, ascertainable claim, ascertained claim, money value 50,000 or more, and relating to any difference arising out of the execution or non-execution of the works contract.
So
These
contractor wants to tell it termination of that.
he has to
Value more than 50,000, then only he can.
My lord, my submission is a challenge to the legality of the termination. It is not the subject matter of the powers of the tribunal. I'm trying to. My lord, that's why I said I have a two-limb argument. First of all, I want to understand what's the scheme of the act. When I understood the scheme of the act, I found that my case doesn't fit into this. My case is that I want to challenge the legality of the termination order because it is bad in law, prima facie. I am not on compensation or loss. No, I will not clarify that aspect. In case not something want to invoke that jurisdiction, they can do it. My submission is I have not canvassed that aspect beyond that. I know that the difficulties would be there.
Mr. Mathur, come to section 3.
No.
Section 3 is having much wider connotations within its sweep.
My lord, section 3 says the state government shall by notification constitute an arbitration tribunal for resolving.
Just a minute. Arbitration tribunal. Pause there. For resolving all such disputes, disputes or differences pertaining to works contract. Termination is also one of the area of dispute or difference, point of difference. If there would not have been any termination, then there would not have been any difference.
Great honor. Point of difference and dispute in my humble submission would be difference. Would be different.
But they have used the word or. All
Differences.
such disputes or differences, they have not said end.
My lord, I claimed 50 crores as a contract. The department says you are entitled to 48.5 crores. That will be the difference.
No.
Difference.
It is difference in viewing a subject. It is not difference of amount.
It has to then the definition of dispute should be like that, which defines a dispute. If my
We can take up as a pecuniary jurisdiction of the fact.
no, my humble submission, it is a composite one.
He says dispute and difference.
It is-
This not defined.
It is a composite method thing. It contains dispute means claim of ascertained or ascertainable money valued at rupees 50 or more relating to any difference arising out of the execution or non-execution of a works contract or part thereof.
Actually, other than work contract, there are no
Apparently it can be said to be only pecuniary.
pecuniary, because we will govern the power and scope of.
But it has not been enlarged by the legislature so far because the definition is still restricted.
Definition of dispute is there. But
Yes.
in section 3, the word has been used disputes are differences.
My lord, to answer
Are two different.
to answer my God's query, can
Differences arising out of any kind of differences arising out of works contract can be referred to the arbitration.
And they have not defined
As per
difference.
section 3, differences has not been defined.
whether this liberty is available to the tribunal to expand its jurisdiction for everything, the foundation.
Only the definition of dispute provided in 2(1)D restricted the jurisdiction of the tribunal.
But the
It can
foundation.
only
But the foundation of filing of a reference is that there has to be a dispute,
why the word legislature has used this word
Not-
dispute are differences.
not in the.
Because it was enough to use this all such dispute.
What they
Dispute
did,
is
what they,
defined under
what,
2(1)D.
what they did, they defined one area between dispute and difference, leaving difference to the discretion of the authorities. And dispute, they are quantified in 3 terms: pecuniary jurisdiction, nature of work, and consequences arising out of flowing out of that. But that dispute, after fulfilling these 3, any difference, fulfilling 3 qualifications given in a dispute, will include any other difference.
When my lord, I began the argument, I was aware of this aspect myself. That when I say that there's a complete code in itself, it will be difficult for me to canvass the subsequent limb of the argument. That so far as the legality of the termination order is concerned, so far as the legality of the blacklisting order, I'll have this problems. But in my humble submission, it is a hairline distinction which I'm trying to make to canvass this point. That in case the jurisdiction has been given in a limited sphere, as my lord has observed, pecuniary limit, can it be taken for the purpose of usurping the powers for other remedies also? If the tribunal cannot usurp the power for other purposes, though prescribed in the constitution of the tribunal, it possesses the power, but it has not been given the powers. Like there are certain say, legislations like RTE, RTI.
It has been given powers but have not been used is one aspect, and it has not been given power and therefore not used. This is another aspect.
Yes, I'm grateful, Mar. It has not been conferred upon the tribunal because the definitions have not so been enlarged. It is still restricted to the pecuniary amounts because the preamble says to arbitrate in disputes and for matters incidental thereto. So, in case, my lord,
What is the section 7(1)?
my lord,
Either party to a work contract.
shall, irrespective of the fact,
United are dispute only, but there is a dispute.
my lord,
And under section 5, the power has been given to reject that reference suddenly without notice. It has not been case for activity.
yes.
But in the preamble, last line uses few more phrases. Is a party and for matters incidental thereto
Or connected
or
there.
connected therewith.
That's why I'm saying it's a perfect legislation. But the legislature must empower it with the desired powers. The definition of dispute is still half or say restricted. Otherwise, my lord, there was no reason for the state government to use the word ascertainable. When the judgment of IVA came, they made only this the amendment. They could have incorporated all these things. Gradually, the legislation is taking shape. But it contains the powers. Definitely, they can do it. And if somebody goes there and they exercise the power in the proper manner, probably that's the only forum available. I'm trying to, my lord, carve out that point for myself that legality of the termination order can still be not challenged before the tribunal. Legality of the blacklisting order can still be not challenged before the tribunal because that original jurisdiction for these two things are not available to the tribunal. It is restricted to the pecuniary jurisdiction. As
Contractor may not claim any amount, but what is ascertainable? So then tribunal gets a jurisdiction. This claim is ascertainable, but although you are not claiming, that's why you got ascertainable. Ascertaining it. Ascertainable hai, but it's not claiming.
that's right.
Even for the purpose of claim, challenging the order of termination, the same can be ascertained or ascertainable that has been decided by the Gori Ganesh by taking the force of court descent. That for the purpose of this the relief, that can be ascertained to the value of the contract, or to the value of the birth left over, or to the value of the revenue recovery certificate. So that can be interpreted in that manner also. This 2(1)D is only for the purpose of the valuation of jurisdiction, and any dispute below 50,000 will not be entertained by the tribunal. Otherwise, every difference which is arising out of a first contract will be referred to the tribunal. So far as the termination is concerned, LG Chaudhary 1 is Supreme Court has said that the termination can be challenged before the
Termination in relation to the claim.
termination of the birth contract can be challenged to the truth.
Yeah, definitely. That is the order which is captioned as a termination order. But I'm saying that legality of the termination order, like for example, it has not been passed by a competent authority. Number two, it has not been passed after hearing me, and it has been passed on various
These issues,
other considerations.
If these grounds are available, then definitely can be considered under 226 also, taking the reports of bulk.
But you are want to challenge there would be a counter case. May not be because of that termination, it's about a law.
Mr. Mathur, another aspect will come into play. There are rules, statutory rules, Madhya Pradesh Adhikaran, Madhyastham Adhikaran Niyam. Now, Rule 7 deals with reference, and there is a form prescribed. Both Rule 7 talks of differences. Please see sub-rule 3 of Rule 7. Every petition shall be divided into paragraphs numbered consecutively and shall contain brief contents of the contract, differences and nature thereof.
No, this would be definitely there. in my humble, I don't wish to say that this would be a subordinate legislation. Will not, because if the legislation is silent on the point, anybody can go with any claim there. But whether the tribunal would feel satisfied.
Rules have taken into account provisions contained in section 3. Section 3, they are
No.
supplementing section 3, they are not supplanting section 3. Therefore, to that extent, they are valid.
No. That's right. They have the rules, then they can do it. My lord, I'll answer my lord's query. If I go into the claim jurisdiction, that this is my quantifiable claim, this is my ascertain or ascertainable claim, kindly pass the award. And then counterclaim is also filed. That is what I'm making. That this act has to be seen, or may kindly be seen from this perspective, that so far as the claims of the contesting parties are concerned, it's a perfect answer. So far as the legality of the things are concerned, constitutionality of the things are concerned, it's the constitutional courts which can pass the orders. I'll not just say they can't. Well, they should not, because the forum is not there. The High Court can very well say, if I don't claim anything as a matter of claim, and I reserve my right in the writ petition by saying that I am challenging the legality, even if they file it, the court will say that the forum is there for the purpose of claim, because this is an independent application. The court can very well ask them question as to why you have filed the counterclaim here when you have a forum there. Either you go there or wait for him. Whenever he will file the claim, you file the counterclaim. Counterclaim is an independent right which one can exercise either on his own or in a proceeding already where the claim is pending. But just to conclude my submission, I'll just read out Article 19(1) to just demonstrate one point of mine. Article 19(1)(g). Article 19 says all citizens shall have the right to practice any profession or to carry on any occupation, trade or business. My third limb of argument, my lord, is relatable to this blacklisting aspect. The person or the organization where I was working has severed its connection for future business or future transactions that we will not deal with you hereafter. That affects my fundamental right. And if I say that blacklisting is nothing but a restriction on a fundamental right prescribed under 19(1)(g), I may not rely upon illustration of other persons who are also by executive instruction saying that in case you are blacklisted at one place, we will treat you as blacklisted for our purposes also. I'm not saying this right now. I'm trying to canvass only my fundamental right, that if I have a right to carry on business, it is violation of my fundamental right on account of passing of the blacklisting order. And therefore,